Next case set for argument this morning is State of Ohio versus Brandon Quinn. That's case number 18CA0022M. And each side will have 15 minutes to present their arguments. Appellant may reserve up to 5 minutes for rebuttal. If you plan on reserving time, let me know and I'll keep you apprised of the time. The arguments are being recorded, so we ask that you stay at the podium and keep your voice up so that the recording is a good one. Because we do record and post these arguments, please refrain from using names of children during your presentation. Now, we have read the briefs and are ready to proceed if you want.
Thank you, Your Honor. May it please the court, my name is Attorney Thomas Erb, and I represent Appellant Brandon Quinn in this action. May it please the court, I would like to reserve 5 minutes for rebuttal.
Very good, thank you.
Your Honor, I would ask for a remand to the trial court today based on the facts and circumstances that arose during a 3-day jury trial of Mr. Quinn. Your Honors, under analysis of 404B and 403A, there were serious issues with a video that was played during the trial. Your Honor, I would like to note that no notice of intent to use this video was ever filed in the trial court. And in fact, the video was never turned over in this particular instance of this case. The state indicated that they had provided this video five years prior in Mr. Quinn's previous trial for voyeurism on what actually was this charge. Mr. Quinn was charged in voyeurism in 2012. They proceeded to jury trial. The alleged complaining witness in that case did not appear. The jury had already been impaneled, to my knowledge, and therefore double jeopardy attached to the voyeurism charge. Fast forward to 2017, when the complaining witness came forward with 11 counts of gross sexual imposition the state indicted Mr. Quinn for, which then proceeded to this jury trial. At the outset, the state indicated that it was going to be playing this video. This video was of a young girl undressing. Your Honors, if you review the record, there were numerous problems with this video. It was not the video that Mr. Quinn's trial counsel had seen previously. It was not the video that the state had seen previously. And it was not the video that the alleged complaining witness had seen previously.
When we review the record, which version of the video are we going to find?
Well, Your Honor, I don't know. Frankly, they stipulated that at some point during the video, the door opened and closed from the outside of the alleged complaining witness's room. And what the trial attorney attempted to argue was that Mr. Quinn was outside of the room and therefore could never have started the video in the complaining witness's bedroom. Regardless of those facts, Your Honor, this video was so prejudicial that the jury asked to see the video during their deliberations on Mr. Quinn's 11 counts of gross sexual imposition. This video did not show Mr. Quinn molesting or in any way doing anything to the young lady. In fact, several times it was referenced during the trial that we were having a trial within a trial. Well, that doesn't make any sense to me.
Who made that reference, the court or counsel?
Counsel for both the state and the defense made that argument, Your Honor, that we were having this trial within a trial. And it was impossible for the jury to separate what was happening on the screen with what was happening in the courtroom with regards to the actual charges Mr. Quinn was facing. The state has argued in their brief that this was the modus operandi of Mr. Quinn. And I think that's a misnomer. In order for this to be Mr. Quinn's modus operandi, there would have been dozens of videos. One thing would have led to the other. If Your Honors are familiar with the movie Point Break, where all the presidents put on the mask before going into the bank to rob a bank, we know one's Jimmy Carter, one's Ronald Reagan, we know who's who. That happened every single time. They have one video, one incident, and it doesn't even show Mr. Quinn doing anything in that video. I don't even think they ever properly authenticated the video that came off of that phone. Because why are we even talking about it? It raises more questions regarding this voyeurism charge that he can't now be charged with than it answers. I think it could have been any crime, and the state probably would have said that it's okay. Your Honor, even at one point, Judge Collier said that he regretted or he wished that he had never shown the video. There were multiple problems during the trial of getting the video to play on the large screen that was in the room to the jury. They discussed the video was sideways. There was the sliver of light incident. Your Honor, in a trial that was about gross sexual imposition, the term video appeared more than 175 times in the transcript, where the terms that we should be talking about in a gross sexual imposition trial appeared less than half of that. The state also attempted to raise the victim's truthfulness by saying different statements during the trial that she was telling that she was being truthful. And I pointed out multiple instances of that in my brief. As such, well, isn't this you're telling the truth, right? And I think that had caused the jury to look at the complaining witness and think about it for a second. And that raises her level of truthfulness. So I do think that rises to the level of prosecutorial misconduct. Your Honor, I also anticipate the state will argue that the introduction of this video was harmless error. Your Honors, the video of a young woman undressing in her bedroom, which has no connection to the gross sexual imposition charges, and the jury asked to see it again while deliberating on the gross sexual imposition charges, can't possibly, in my opinion, be harmless error. The jury looked at that video, they convicted Mr. Quinn based on that video, and I don't think we can unring that bell. Thank you.
Thank you. You'll have your full 5 minutes for rebuttal then. I'm going to say that's 15 minutes.
Good morning again, Your Honors. Vince Vellucci with Medina County Prosecutor's Office for the appellee of the state of Ohio. And most of these assignments, I think 3 out of the 4 do have to do with, at least in some part, with the cell phone video. And this is of the victim, Shannon, getting dressed in the morning. This video, first of all, to address the 403 matters, was highly relevant to this case. This video was the impetus for Shannon to leave her house initially, or get kicked out of her house, whichever side you believe there.
I know they're different last names here, but let's just try to refer to her as the young girl or by initial or something, okay?
The victim, I can say the victim. Going to live with her aunt, then going to live in Michigan. This is what caused her to initially come forward, at least about this misconduct, this sexual misconduct on Quinn's part. Within the year, she was up in Michigan actually disclosing the rest of Quinn's misconduct, the gross sexual imposition part of this. And then that would be late, I think, 2012 or early 2013. That video really started this whole chain of events. It's also independent corroboration of Shannon's story. It's something physical, concrete, that exists outside of just her statement.
But his argument is that that doesn't go to any of the elements because there's no touching involved there. You may be guilty of voyeurism, but that doesn't go to the elements of sexual imposition. And if that were the case, I would do a compound question. And if that were the case that it was going to the elements, why would you need 404?
Well, actually, I'm not saying It does go to the elements of
I'm sorry, I
this
thought
crime.
that's what you said.
No, I think maybe the word corroboration isn't the best word, but it makes her testimony far more credible when you consider this. I think it is 404B evidence. It's classic 404B evidence for several reasons. I think you start with proof of intent that the touching was not accidental.
Well, did he raise that as a defense? Was there any allegation in the trial that he had touched her accidentally, or just that he didn't touch her at all?
I don't think it was ever stated that he didn't touch her at all. I think
I thought he was denying everything.
his story, I think, is that he would come and wake her up in the morning, which I imagine would involve maybe some touching, but I don't think it was ever said, I never even got anywhere near her. But
Well, I should change my question to you. I don't know that there is any allegation that he didn't say I ever sexually touched her, or he didn't agree that he had touched her in any of her
erogenous.
erogenous,
Yes.
I guess that's a good way of saying it.
Correct, yes. That is correct. I think you also look at, when you're looking at his motive, I think this clearly goes to his sexual motive when it came to the victim. Perhaps most compellingly, though, is, as Mr. Erb mentioned, the modus operandi in terms of establishing Quinn's identity by showing that he had committed similar crimes with an identifiable scheme or a plan. It's not a huge leap to go from recording a young girl, getting dressed in the morning with your cell phone, to then touching her inappropriately in that same bedroom in the morning. I quote the Lowe decision in my brief because I think it's very eloquent when it talks about modus operandi. It says, quote, "A certain modus operandi is admissible not because it labels a defendant as a criminal, but because it provides a behavioral fingerprint which can be used to identify the defendant as the perpetrator. Other acts evidence is admissible to prove identity through the characteristics of acts rather than through a person's character." And that's exactly what we have here. We have the characteristics of acts, not Quinn's character.
Did the state provide notice of the use of the video under 404?
I don't believe so, Your Honor. At least not within the 10 days. I don't believe. But I think
Shouldn't you have had a hearing on that?
I don't think that was required. I think the court for good cause can waive that, and I think that's what happened here. I don't think that's just a hard, if you don't file that notice, you absolutely under no circumstance can use this evidence. No, I don't think that's the law.
Why is the video different than the camping incident that was excluded?
The camping incident, well, we argued that should have been admitted as well, but at length actually, and that goes to one of the prosecutorial misconduct claims, because that was mentioned in opening statement by the prosecutor, who was not saying that in bad faith, by the way, because he had no way of knowing that was going to be excluded. Frankly, I think they're both admissible other acts evidence that go to what I just said. Modus operandi to prove identity, plan, scheme, also the sexual motive, like I said. And if there's any question as to whether this touching was accidental, when he's waking her up in the morning, and he just happens to touch her, I think that was the suggestion. I don't think he ever denied waking her up in the morning. It goes to his intent as well. I think it goes to, it's a classic 404B for all of those. And we would argue that should not have been excluded, actually. I think they're similar, but I think the cell phone is even more relevant than the camping incident, because it is taking place at the same place and time, in her bedroom, in the morning, and it's his cell phone that's in there. And that is compelling evidence that he put it there. And this touching, in fact, wasn't even the only activity that he was engaging in when it came to the victim here.
So was the video a total surprise to the defendant? I mean, was it not in the file?
Absolutely
Prosecutor's
not, Your
file?
Honor. Absolutely not.
Were there reports about the prior incident in the file? How would he have known that the state was going to rely on this cell phone video? I mean, I could see if it was in the state's file on discovery was exchanged.
I
There was
think they
no
knew,
notice here.
and I think they had this video from years earlier, and this wasn't a surprise.
How did they know that the state intended to use it in this trial if it was, and I don't know if it was in the state's file or not, or if there were reports associated with the voyeurism trial in the state's file this time. I mean, my
And-
concern is there's no notice that was filed.
Well, I think defense counsel even admits that he had viewed this video, he had this video, he had a copy of this video. Whether it was in the state's file or not, I'm not entirely sure, but I don't think that should matter, because he did have notice of this video. He had it, and he
Well,
reviewed it.
Counsel, I'm not sure I follow that, because somebody has all kind of notice of witnesses. We could make that argument, well, we don't have to provide a witness list because you knew your mother existed. I mean, we can't do that, can we?
Well, I think, well, I don't think there was a witness or exhibit list required to be filed here, first of all.
No, I'm not
But-
suggesting that. I'm just saying, go ahead.
I do understand what you're saying, though. The idea that the victim here was going to testify, and that this video would not be a part of her testimony. This is a huge part of this case, and in fact, she would not be completely and accurately telling her story if this video had not been part of it. And in fact, playing the video actually, I should say not playing the video, I think there's a strong argument that could have prejudiced Quinn, because, as I said, the victim had to talk about this because it was the impetus for this entire case and this entire chain of events that she had to talk about to tell her story. And if it had just been laid out there that there's this video and it hadn't been played, I think the jury would have been free to speculate as to what was on this video, and it could have thought anything, and then that could have prejudiced him. I think this way, the jury actually got to see the video and make a decision for itself and make its own conclusions about what that video showed.
So when did, I know you argued with the camping incident, but did you argue with the trial court, I can't remember exactly what happened, that this was 404B evidence with the video too?
Yes.
And so when is the first time the defendant knew that it was going to be used as 404B evidence? Let's say he knew the video existed. That doesn't mean necessarily he knew it was going to be used as a prior act.
I believe it was fairly early in the trial, and it was throughout the trial. Quite a bit of transcript is dedicated to this, if I recall. It's been a minute since I read the transcript, but this was a consistent theme of the trial. I think we can agree with that on that. Now whether the prosecution ever used the term trial within a trial, I don't recall that. I don't think the prosecution used that term. I'm sure the defense did, but.
Well, counsel, the other question I have, because I know we ran out of time, so I want to ask this. Wouldn't it have alleviated these issues with what the prosecutor said in opening statement if you had, I'm not saying you, if the state had provided notice of 404B evidence so that everyone could have been looking at it and the judge could have decided whether it got admitted into trial or not, or whether it was able to be played, or whether it was able to be testified to?
I think it was. I think it may have been decided even before opening statements.
Well, I can't imagine that the prosecutor would have gotten up there after the judge had told him he can't get into the camping incident and then talked about it anyway.
No, and that happened later later on, but the video was something that was addressed very early in the trial, and it was, the victim was actually the first witness for the state. But
When the video was addressed, was the specific objection raised regarding there was no notice of intent to use? Or was it all of the other legal argument regarding the video? What, do you recall if the transcript is going to show the defense counsel, trial counsel at the time raised that as one of the objections to the video?
I'm not 100% sure on that, but I do know the main thrust of the argument was the 403, 404, not relevant, not 404B. That was most of it. I'm not really sure about that.
You got about 2 minutes, just to give you an idea.
Okay, I will just move on to, well, in terms of the video itself being different from what counsel was talking about it had previously seen, I think that's really much ado about nothing. There is a fair number of pages dedicated to this in the transcript, but what it ended up being was it was just a little bit darker on the court's flat screen than it was as both counsel, the prosecutor said this too, had previously viewed it on computer screens, and it just looked different. It was lighter, I think. And there was a door opening previously that they'd seen with a crack of light coming in. That was the difference. So that ultimately ended up being resolved with a stipulation that the video had previously shown this door opening and this light coming in. So I think that's really much ado about nothing. It wasn't in terms of like, we don't even see the victim anymore or anything major like that. It was right at the beginning of the video, the trial counsel for the defense objected, and that was sort of resolved. I think a lot of this misconduct, these claims, happen on cross-examination by the prosecutor. And it stated that it was during direct of the victim in some of these cases, but actually the defense recalled the victim as its own witness and then directed her, and then the state got a chance to cross-examine the victim. And I think all of the things that that Quinn is complaining about in that happened on the prosecution's cross of the victim, in which he was allowed to ask leading questions, which is what he did. Am I out of time?
You're out of time. Wanted to let you finish your thought there, but thank you.
Thank you, Your Honor.
And that leaves us with 5 minutes for rebuttal.
Thank you, Your Honors. Again, we're asking for remand of this. Your Honors, to my recollection, to address some of the points that the panel made, this was not on the state's witness or exhibit list prior to trial. There was no 404B hearing regarding either the Hockey Hills incident or this video, which is why Attorney Bailey objected to the Hockey Hills incident in the prosecutor's opening statement. The judge did allow him to continue with that opening at that point, saying he would rule on the Hockey Hills incident later. And when the judge ruled on the Hockey Hills incident, if you read the transcript, the judge actually said, I can't let it in. I just can't. If it was charged conduct, I could. The state has made a big point today that this is why she came forward. Your Honors, this incident was in 2012. There was an entire criminal investigation of Mr. Quinn in 2012 revolving around the voyeurism incident. At no time in 2012 did the alleged witness ever come forward with these allegations. She went to Michigan. She told her father and his girlfriend. His father and his girlfriend told no one. They didn't call Medina County and say, you need to investigate Quinn for these actions. Her father did not drive down to Medina County, where his 2 other boys were living with the victim's mother, and knock on the door and say, what is going on down here? Nothing happened when she allegedly told her father in 2012. 2013, 2014, 2015 pass. She says nothing until she calls the state of Ohio and sometime during that year, and these charges are filed almost 5 years from the indictment in the voyeurism case. They were both, one was filed in April of 2012, my recollection, one was filed in April of 2017. Your Honor, additionally, the state's asked you to take a notice of stuff that's not in the record. There was no doctor or psychologist or anyone who testified that someone who videotapes someone is also prone to touch someone. That's all information outside of the record. If the state wanted to do that, they should have called someone who could connect those dots. The fact is, we don't know who took that video because there was never a trial on that video. And to appear with it 4 years later, with Attorney Bailey having no notice, he may have had the tape for the 4 years and the files shoved somewhere from the voyeurism tape. I can't speak for Attorney Bailey. But the day he showed up for trial, he was preparing for one trial, and then within a matter of the victim being called to testify, we're now in a different trial. We're now trying a voyeurism case, and that was the trial within a trial that I represent, that I discussed earlier. Your Honor, it's unfairly prejudicial if it arouses the jury's emotional sympathies or evokes a sense of horror. I think I could state that it was horrific, having that video played in the courtroom on that day. Your Honor, based on everything that I've discussed here today, I believe a remand to the trial court is necessary. I believe Mr. Quinn deserves a new trial without this video being present, and I would ask the court to do so. Thank you very much.
All right, thank you. Thank you both for your presentations today. The court will also take this matter under advisement, issue a decision in due course. The clerk of courts will mail counsel a copy of the decision and once it is released. And the opinions are also posted on the Supreme Court of Ohio's website if you care to check there as well. Thank you both for your arguments today.
Thank you.